Hello everyone, and thank you for clicking on time for a PEP Talk video I've produced. Now this video is in response to a blog post that I initially had written on LinkedIn. Many people had read it, and the feedback I got was the blog post was way too long, but very useful information within it. What they wanted was to review all the information, all the data within one short sitting, and they couldn't because of their busy lifestyles. And the suggestions were made, top and foremost being a presentation video. Now I have a background in lecturing, teaching, as well as compliance, so putting the two things together, I decided to make this video. I'm hoping to create more videos around trade-based money laundering, hedge fund, trust fund, due diligence processes, risk assurance, business process systems, all types of governance, risk and compliance that I know of and have experience with in my life. This video is going to be at least 2 because I just couldn't fit it in within the time frame. So you can imagine how much I've written in the blog post. The aims and objectives of this particular video is, first things first, the definition of a PEP that we'll go through. We're going to define the 2 discrete categories of a PEP as well. We're going to identify the 4th AML directive surrounding PEPs, AML meaning anti-money laundering directive. We're going to view the legislative and regulative guidances on PEP classifications. We're going to identify the importance of PEP internal controls via case studies, and then we're going to carry out a quick summary on what we've just done. Now I must let you know that I'm not a specified expert on PEP KYC, and I don't know who gets classified as a specified expert on PEP KYC other than people like myself just coming on board and saying, you know, this is what a PEP is. So by default one becomes a specified expert on PEPs. I can only write what I know from the knowledge gathered throughout my work experiences. I mean, courses attended, books read. I love reading a lot of books, especially on my expertise or my career. Regulations that I've studied, and the conversations I've had with other experts on PEP KYC. And I invite you all to chip in on the comments on how we can improve a deeper understanding to make a more holistic view on this subject matter of PEPs. It doesn't seem complex at first, but once you get into the nitty-gritty, it is quite complex because the business wants something and the regulators want something, and you have to somehow, as a due diligence officer or a compliance personnel, you have to somehow work in between the two and see if there's any way which both parties are happy. Okay. So what is a PEP? Now this is one question that I like to ask all my teams, and some worrying answers received from a number of individuals within the customer due diligence side, compliance side, even senior managers in compliance that I decided to initially write my blog on. So the first things first was someone who stated it's someone who's exposed politically. Yes, great. Tell me something I don't know. Someone else was a bit more worrying, said it's someone on the SDN list. One other person even said it's the president. No, and then when I asked who the Prime Minister was, they basically weren't sure if that person was a PEP or not. So that was a cause for concern. And someone else basically stated, let me check the regulations like money laundering regulations, FATF, JMLSG, etc. And these are worrying answers from so-called experts on due diligence, carry out due diligence every single day, yet they provide answers like these. It just means that further training is needed, and the training that's being provided is obviously not adequate enough for them to understand. So senior management, more so the directors, especially in today's world, need to look into providing specified training to specified individuals and not just the generalization. Okay, so let me go through what a PEP is. Now, a PEP is a single individual who is or has been entrusted with a prominent function. That's as per the FATF guidelines. It further goes into, due to their position and influence, can conduct bribery and corruption, money laundering and terrorist financing easily. And the UNCAC Article 2 goes on to state that their family members and close associates are also included. And this is not just the UN stating that, it goes into the money laundering regulations. The JMLSG guidance states the same thing. Includes their immediate family members, close business associates, as well as any senior executives of state-owned enterprises. We'll go into state-owned enterprises afterwards. Now, what are the legislative and regulative guidances on PEP classifications? I mean, how do you know what's a PEP and what's not a PEP? Now, upcoming fourth EU Anti-Money Laundering Directive broadens the definition of PEPs into two discrete categories. One being domestic PEPs, persons entrusted with a prominent public position within the EU, and include persons present in the EU who work for international organisations based outside of the EU. And secondly, is foreign PEPs include prominent individuals from outside the EU. Okay, so that's all. We're used to the foreign PEP side of things. There's something I want to just stress here. The fourth Anti-Money Laundering Directive, which follows the updated recommendations of the Financial Action Task Force, is something that many people are now coming to terms with. The inevitable change that domestic politically exposed persons are no longer exempt from enhanced due diligence, meaning everything's enhanced due diligence now. They are categorised with the same scrutiny as foreign PEPs, and for organisations to use a risk-based approach. Now, this term risk-based approach is coming on everyone's lips now. In every meeting that I've been to, I'll be shocked if there's not the term risk-based approach mentioned somewhere and put in somewhere. So risk-based approach basically just means it's on us. We have to categorise the risk according to our organisational risk appetite. Yes, the organisation has a risk appetite, but then there's a risk tolerance as well. And within that risk tolerance is basically, risk appetite is the appetite that the organisation is willing to take risk of. Now, risk tolerance, however, is how much the appetite can stretch further. And a lot of these PEPs are within that risk tolerance area. So you have to keep in mind the risk-based approach and keep monitoring PEPs and what have you to keep them within that risk tolerance. Once they go out of that risk tolerance, then you really have to look into what avenues you can go down and speak to senior management about that. Okay, the usual legislative regulative guidances on PEP classifications is heads of state, heads of government, ministers and deputy or assistant ministers to be understood to the level of middle ranking or above, members of parliament or similar legislative bodies, members of the governing bodies of political parties, members of Supreme Courts of Constitutional Courts, or of other high-level judicial bodies, the decisions of which are not subject to further appeal, except in exceptional circumstances. Remember that. Not subject to further appeal, except in exceptional circumstances. So that's not everyone who's associated with the Supreme Court, it's high level. Okay, members of courts of auditors or of the boards of central banks, ambassadors and charges d'affaires with high ranking officers in armed forces, apologies for my accent there, members of the administrative, management or supervisory bodies of state-owned enterprises, directors, deputy directors and members of the board or equivalent function of an international organisation, and note to be understood to the level of middle ranking or above. As well as the above, PEPs also again include close relatives, close associates and business partners of those classified. Now there's an infographic here supplied by Acuity, which I am very thankful for, and I use it quite a lot, and I keep one to hand for every one of my team members with my due diligence officers to just have a quick glance at as a quick review on PEPs and what have you. There's a lot of things that a due diligence officer has to look into, and PEPs can sometimes go amiss. So it's always good to keep something like this infographic there for them to have a quick reference for. Now, transactions and or relationship with PEPs, the financial institutions must, number one, have in place appropriate risk management systems, including risk-based procedures to determine whether the customer or the beneficial owner of the customer is a politically exposed person. So remember, we're looking whether the customer or the beneficial owner of the customer is a politically exposed person. 2, we're going to apply the following measures in cases of business relationships with PEPs. 1 is obtain senior management approval for establishing or continuing business relationships with such persons. The other is take adequate measures to establish the source of wealth and source of funds that are involved in business relationships or transactions with such persons. Just a quickie here, source of funds, source of wealth is very important investigation to carry out. This is where money laundering actually takes place, and they're probably being bribed or corrupt, those that are carrying out money laundering activities. The fraud or what have you the corruption level has already done and happened, and they're just cleaning their process. Remember, placement, layering, and then integration, the 3 processes of money laundering. So that's what they're doing with yourself if they're in there. Okay, and then conduct enhanced ongoing monitoring of those business relationships. Okay, so when is PEP not a PEP? A lot of people miss out this definition, and it's really good to keep in mind. Now, where a PEP is no longer entrusted with a prominent public function, financial institutions must consider a continuing risk posed by affiliation with such PEPs for at least another 12 months, notice or longer. It doesn't just stop at 12 months, it's or longer if the financial institution determines that the risk specific to such a PEP has diminished. And what they are saying is we have to apply our own risk-based approach on this matter. Now, note that there is no fixed criteria for a PEP. Although the directive helped clarify PEPs somewhat, the fact remains that there is no fixed criteria for a PEP. So where do we look for guidance on PEP classifications? Well, firstly, there's the Financial Action Task Force, FATF, or Recommendation 6 states the definition of the PEP. Recommendation 12 goes into customer due diligence, including the enhanced due diligence process or the due diligence process on PEPs. And Recommendation 22, which is the internal controls, which includes PEPs, on how internal controls should be carried out for senior management. There's also the Money Laundering Regulations 2007, the section of 14 paragraph 4, definition and enhanced due diligence process on PEPs. The Schedule 2 is a more detailed definition on PEPs. Third EU directive, Article 3.8, definition of a PEP. And JMLSG, the guidance is very useful. Enhanced due diligence on PEPs. Politically exposed entity, the PEE, where a PEP is a director or shareholder, including sovereign wealth funds. Further definition and monitoring guidances on PEPs. Now, the UN, United Nations Convention Against Corruption, Article 2, states the definition of PEPs. Now, the recent view of the importance of PEP internal controls, a lot of people say sometimes that one is being too fanatical. After all, the screen data tools have it all programmed into them. And that is actually wrong. The data tools are simply there to make our admin work more efficient, not to take away your responsibilities. Remember, outsourcing data management is just that, outsourcing the data management functions. Risk management functions, on the other hand, stay with the organisation. That is what the regulations state. I mean, SYSC 3.2.4, 13.9 and the JMLSG Part 129 also state that the liability sits with the organisation, not the data system or screening tools or the outsourced KYC team or firm. Now, the global Dow Jones watchlist database alone contains over 400,000 unique records of PEPs, including their relatives and close friends, close associates rather. So there is a lot of PEP related investigative work needed before the report leaves the front line. Now here are some case studies where they haven't done such a thing. Barclays was fined in 2015, Standard Chartered was fined in 2014, EFG Private Bank was fined in 2013, Coutts was fined in 2012. What's worrying here is we are going through the same failures and the same types of customers. It means we're not learning our lessons. It means something really needs to be done. Now, the summary of what we've discussed was we went through the definition of PEP, including what is a PEP, the two discrete categories of a PEP. We covered the fourth AML directive surrounding PEPs. We covered the legislative and regulative guidances on PEP classifications. We covered the importance of PEP internal controls. And in the next session, I hope to provide you with the behavioural science side of things. But we have to keep all these things in mind when looking into what the motivation behind a business relationship is for the PEP. PEP risk exposure, the 4 levels of classifying PEP risk. PEP enhanced due diligence process. What does it mean to exercise reasonable judgment? And finally, we're going to be looking at the term special procedure. What does it mean by that? Now, I wish to thank you. For any questions or inquiries, please feel free to comment below or get in touch with me.